Is there such a thing as a common law partner? Legally speaking, there is no such thing as a common law partner.
However, the term is coined in the media as someone who's in a long-term relationship and is cohabiting with another person at the same address on a permanent basis.
So what is a common law partner entitled to?
In the event of a relationship breakdown, it is a misconception that unmarried partners are entitled to 50% of all assets accrued during the relationship. So determining what each unmarried partner is entitled to from the relationship is normally a time-consuming process that requires the help of a qualified legal professional.
This is especially true if the relationship breakdown has not been amicable and the parties involved cannot come to an agreement in private.
Unmarried partners aren't entitled to a share of their former partner's pension, or to inherit their estate in the event of their death, which can leave some individuals at risk of not being provided for, regardless of the amount of time the couple has lived together. In the event of a separation where children are involved, unmarried partners given the role of the primary caregiver can seek child maintenance support for any offspring arising from the relationship.
What is the difference between unmarried partners and civil law partnerships?
The main difference is that those in civil law partnership relationships are recognized and protected by UK law, while unmarried partnerships are not. Legal protection for civil law partnerships offers clear-cut guidance and outlines rights relating to things such as inheritance, pensions, and taxes. Without this framework, legal issues, rights, and responsibilities arising from common law relationships are often more difficult to settle.
What does cohabitation mean?
Cohabitation means living together in the same residence for an extended period of time, generally as husband or wife or as part of a romantic relationship.
Are cohabitation agreements legally binding?
Cohabitation agreements are legally binding and provide peace of mind in this often complex area of family law, and can be put in place by a family law specialist. A cohabitation agreement sets out how the parties will share financial responsibilities while living together, and what should happen if one person falls ill, dies, or should the relationship come to an end for any other reason. They can also be used to cover specific arrangements for any children resulting from the relationship, to provide certainty, and avoid costly and lengthy legal disputes down the line.
How does cohabitation affect divorce settlements?
Although many people wish to move on as quickly as possible once a marriage comes to an end, cohabitation with a new partner can significantly affect a divorce settlement, regardless of how long the relationship has been in effect, or the circumstances surrounding it. When legal professionals gather to decide the amount to be paid to ex-spouses in a divorce settlement, a legal judgment is made, using established facts presented to the court by the legal representatives of both parties. If one of the parties is now in a new relationship and is cohabiting with them, the judge will ask what financial contribution is made, or should reasonably be made, to the ex-spouse towards their financial needs. Cohabiting may not bring spousal maintenance to an end completely, but it does signify a change in their circumstances that warrants further consideration, as it alters the resources and needs of the cohabiting party in the eyes of the law. This could lead to financial settlements being paid to the ex-spouse now cohabiting with a new partner being significantly less than expected.
National Legal Service family law solicitors can provide you with the best way forward, whether by legal aid or privately funded. Contact us now for a free initial consultation.